Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Me bring the jury.
Hello, everybody. Happy Tuesday to all of my couch potatoes. Hope you're doing well today. You just give me today. The lovely Buffy is off gallivanting like an arguably famous YouTuber living the dream life. Just kidding. She's at the dentist. She would much rather be here, I am sure, but she'll probably be in the chat later. Anyway, hope you all are doing. Speaking of, there she is. You're not off gallivanting? Oh, well, that's too bad. No, I'm just kidding. um, hey, I am trying to make your life seem more exciting. All right, that's what friends do. I'm your hype lady. That's what I am. All right. Well, you guys, today we are finally going to be all caught up with the O'Keefe v. Reed wrongful death lawsuit. Caught up because it's still ongoing. That means after today, when anything live happens, a filing, a hearing, we're going to be able to cover it in real time and come live right with you guys. So that's nice. Yay. Round of applause for everybody. Because it's been a long 4 weeks. It's been a long 4 weeks. I'm happy to wrap this up and be caught up for sure. I even checked the docket this morning. There's nothing new out because I was like, wait, just you wait. This is what I was thinking last night. I'm gonna have it all put together and then they're gonna file like 10 things. And then I'm just gonna be not caught up and annoyed. But as of now, no. No, not at all. So we're gonna catch up with that. And then next week, we're gonna continue on with the next civil trial. It's a fairly new one in the Karen Reed civil rights or civil trial sagas. It is the Ham, which is Higgins, Brian Higgins, Colin Albert, Brian Albert, Jen McCabe versus Reed and Turtle Boy. That's the next one we're going to get into. And I'm very excited about it because there's a lot of stuff in it I don't know because I don't really know that much about Turtle Boy. I mean, I know who he is. I've watched like I don't know, 5, 10 videos of his over however many years. So a lot of stuff they bring up that I haven't read or seen or heard. And in order to prepare for this, we're also going to start rewatching the Karen Reed trials, starting with the first one. As it turns out, many in my chat didn't watch them when they happened. So we need a refresher anyway to get into all of these civil cases, and because it's a mess. It's a big old mess. So we'll be getting into that next week, and we're gonna have a lot of fun with it, guys. I'm very excited. I was up till like 2 o'clock in the morning planning, and then I realized my plan was crap. So I got to do that afterwards. But let's go ahead and get into this, and we can talk more about the Ham Reed Turtle Boy later. Let me move my stuff. Make sure I'm sharing my stuff now. We do have a couple of hearings today. None of them are relatively very long. I mean, one is like 3 minutes. So there's about 4 of those. The rest is just my handy dandy slideshow because that's just me. That's not right. See, above, you're not here, and everything feels weird. Weird, and I don't like it. I went ahead and read all the documents and summarized them so you don't have to because they're not that interesting. But I summarized them and I made a cute little slideshow for you guys. So that's all we have to go over for today. I don't know how long it's going to take. It could take like an hour, it could take 4. I don't know. But we're finishing it today. So I got my coffee here. I got my Alani over here, which I need to order more because I only have one left. Rookie over here. So where we left off in the timeline was Judge Gilday was big mad. He was very, very mad because he said that somebody on one of the legal teams was leaking private information of Michael Proctor, privileged information, i.e., medical stuff, right? He's real mad about all the teams. He made them like write letters and sign them that it wasn't them. And he did a whole hearing where he gave them his I'm disappointed talk. As a matter of fact, the other attorneys weren't allowed to say anything. He just made them all come in, gets up there, sounds very disappointed, and then gets off the bench. And Jackson was there and he was like, he goes to the clerk and he's just like, can I have some things to say about that to put on the record. Can I do that? And the clerk is like, no, he's not seeing anybody. And they're like, oh, okay. So then her side files motion right afterward, not a motion. I'm sorry. Oh, yes, it was a motion to clarify the record. And it turned out what the judge was upset about was some ex posts, but he was wrong about the timestamps on them. He thought the information came out after, meaning somebody would have leaked it, when the information, according to Karen Reed's attorneys, came out earlier than they knew about it. So, um, yeah, it's not great. Judge is very, very not happy. And then, of course, nobody is cooperating with turning in documents, sitting for depositions, the McAlberts, the police. Nobody wants to cooperate, and they especially don't want to cooperate with Reed's defense teams. So that was pretty much a wrap up of June. And today we're starting back on July 2nd, 2026 with let's see what it says, plaintiff's memorandum in support of motion to compel further answers to plaintiff John O'Keefe's first set of interrogatories to defendant Karen Reed. So they want Karen Reed to answer more of their questions and they want the court to make her do it. Literally, like every other filing is just a motion to compel because nobody's cooperating. And the judge is like, why can't you just get along? It's like, have you met them, judge? All right. Because I've been covering them now for like a month and I can tell you they're going to make everyone do everything. So you might as well just be prepared. But I'm sure he's going to have something to say about it. So anyway, let's get into it. Hi, Pam. Good morning. Hope you're doing well today, babes. Happy to see you. Speaking of, there we go. Oh, I gotta play some music, so my headphones don't shut off. Mm, Un momento, please. I'll play something, and you guys probably won't hear it, but that's okay. I don't know. Can you guys hear that? Might as well. All right. At least now my headphones won't just shut off, and they're not supposed to do that anymore. Whatever. All right. So back in March. Oh wait, it's just one of me. We'll go with that one. All right. So back in March, the plaintiff sent Karen 3 formal written interrogatories. And instead of answering them directly, Reed's lawyers blocked the questions by filing formal objections, calling the request private, irrelevant, and a fishing expedition meant to harass her. Diller would never. He would never. Now, the two sides tried to talk it out in May, but couldn't reach an agreement. So, what are these questions? These simple questions the plaintiffs just want Karen to answer. Why is she not being cooperative? Clearly, she's the bad guy in this. Am I right? So, the first question. Question 1. Who was her primary care doctor for the 2 years leading up to the incident? Well, Reed refused to answer, saying her health is private and not relevant. And the family argues they need this name to request her medical records legally. I don't understand why they did this for this whole incident, but okay. Okay. Hello, lady in gray. Hope you're doing well today. Hi, babes. Question 2. What medications, prescription or over the counter, did she take or have access to during the 48 hours surrounding the incident? Reed refused to answer. The family argues that this is crucial because they need to know if any drugs were mixed with alcohol to worsen her driving impairment. And they note that Reed's own father told a 911 operator that night that she had multiple sclerosis, MS, and access to a boatload of pills. I don't understand why they need this information. She's been charged and convicted of a DUI. So I don't think it's a it's an unsolved mystery of whether or not she was, impaired. She was clearly legally impaired enough for the jury to find her guilty on that. And her own words. Her own words is really what got the guilty verdict for the DUI when she did that interview and talked about how many drinks she had. It was like 7 or 9 or something like that. And you're like, yeah, girl, you were definitely drunk. So I don't know why they need to add in additions to her being even more inebriated. Seems ridiculous and redundant. Question 3, what are the details of her financial purchases and credit card transactions during the same 48-hour window? Why? What are they wanting to get out of that? I don't understand. Because, listen, the state wanted nothing more than to find her guilty of John's murder. All right. They spent a fuck ton of money, millions of dollars to prosecute her, 2 trials. And what do you think? If they had something, you don't think they would have used it? Because they certainly would have. The problem is they didn't really have much of anything. So I think that's kind of ridiculous and weird. This is just to humiliate her more, like they can. It's stupid. Exactly. I think it's stupid too. It doesn't really make any sense. I agree. I think it's irrelevant. Hi, Rob. Good morning. Hope you're doing well. Hey, I'm going to watch your Scout and Brothers stuff this afternoon once I'm done here. I saw your message and then I forgot, but I'm going to watch all of that tonight. I heard it was interesting. So, by the way, if you're interested in the Skelton murder, or I'm sorry, the Skelton boys who are missing, but their father is on arrested for their murders, even though they've never been found. They're having an evidentiary hearing this week, which is a really, really big deal because many of us have been waiting for years for answers to this. So go over, subscribe to Hey Rob on YouTube because he's covering it and streaming it, I do believe. So anyway, so they want to know her transactions. Now, Reed only named her banks but refused to give transaction details, claiming it is too difficult, irrelevant, and protected by lawyer-client confidentiality. So are they wondering how much she's paid out in legal bills, or did she lawyer up in 48 hours? Because it's only the 48-hour window. Interesting. The family argues that looking at a mere 2 days of receipts is easy to do and will prove exactly where she went and what she bought, like alcohol, that night. They also note her lawyer promised to hand over this data during their May meeting, but never did. Okay, well, that's stupid. That doesn't really make any sense. We know she was drinking, but okay. The plaintiffs are asking the judge to step in, reject Reed's objections, and order her to completely answer all 3 questions within 10 days. I think they're bullshit questions, is what I think. Didn't she just sit down in our last coverage of this? She sat down for a deposition. Why? I don't understand why you're still asking her to answer these interrogatories, and yet you had her sit down for deposition just a few weeks before this. I don't. Did you forget to ask her, or they just objected and you're like, I'm going to ask the judge anyway? Maybe. Oh, yeah, Lady in Gray. Well, maybe we'll do a watch party later. Hi, Mary. Good morning, Mary. Hope you're doing well today, babes. All right. So the next document is Karen's opposition to the plaintiff's motion to compel further answers to her interrogatories. So her lawyers argue that this request is unnecessary because she has already provided her bank and credit card statements showing all of her purchases and transactions for those specific dates. Her defense team argues that the court should reject the request for her medical history for several reasons. I mean, how about no? How about that? How about no? This is why I cannot be a lawyer. How about no? Thank you. We're not going to do that. Stop being stupid, Diller. We're not doing it. I get in so much trouble. Now, under Massachusetts law, individuals have a right to privacy regarding their medical records and medications. Her lawyers argue that her general medical history has nothing to do with the lawsuit. While the plaintiffs claim the information is needed to prove she was impaired by something other than alcohol, the defense notes that across two criminal trials, it was never alleged that prescription drugs played a role in the incident. Exactly. Because if they could have, they would have. All right. When we go to rewatch these trials, for those of you that haven't seen them, it's nuts. But trust me, they would have given anything to use those as well. It's pretty wild. The plaintiff based the medical request on a 911 call where Reed's father expressed concern that she had a boatload of pills and might overdose. The defense explains that her father was simply worried she might harm herself due to the emotional trauma of learning her boyfriend had died, not that she was driving under the influence of pills. Yeah, I never once took that to mean that from Mr. Reed. I think a reasonable person would be like, yeah, that's probably why that's relevant. But also, you can have people that, try suicide. They can take any pills. Now, not a lot of them are good ideas, right? You take a bunch of Tylenol, that's a really bad idea. It's going to be way worse. But it doesn't have to be like certain kinds. Not everybody, knows those sorts of things. But also, what she has MS medicine. All right. I don't understand why Diller does these things and goes after things that are like, what? Why are you focusing on this, Diller? You kind of have your hands full, don't you think? And what, you're going to prove that she was more inebriated? It really doesn't matter. You have the conviction for a DUI. Bring up your witness from the trial, whoever calculated it. That was also very weird math, and go about it. That's all you need to do. Now, Reed was already convicted of operating under the influence of alcohol in a previous criminal trial. Because her official blood alcohol level and toxicology results from that night are already part of the public record, her lawyers argue there is no legal reason to invade her privacy by digging into her private medical past. Agreed. Now, ultimately, the defense argues that the plaintiff's requests are improper. They are an improper fishing expedition and asks the judge to deny the motion. It's stupid and it makes no sense, and I will rule on that. Granted. Good argument. So the next filing, still June 2nd, lots happens on certain days in this. The plaintiffs reply back to Karen, and this is what they have to say about that. So they argue that knowing what prescription medications Reed was taking is highly relevant because certain drugs can increase the effects of alcohol. They point out that during her criminal retrial, her own lawyer stated that medications can affect the water levels in a person's blood, which directly impacts how blood alcohol concentration is calculated. Okay, but it's not. This trial is going to be so difficult. I don't think it really matters. If it's over a certain level, you're inebriated. So, good God. They did blood work on her and found nothing but made up an alcohol test, right? I can't wait to re-watch all of that. The only reason she was found guilty of it is because she literally said and herself how many drinks she had. And as soon as she said that, I remember when we were watching the second trial, I was like, yep, there you go. She's definitely getting a guilty on that one. Someone your size ain't drinking 7 drinks. But the state even messed up all of that. It is going to be ridiculous. I am so excited about it. There's not many trials I like rewatching, but what's that music? It's something in StreamYard. Hi, Mom. That way my headphones don't die. So, is it super loud? I can turn it down. I just need it so that way my headphones are like, oh yeah, things are going on. I can turn it down a little bit. There we go. Sorry. I don't know what it sounds like for you guys. All right. So the plaintiffs argue. All right. Next slide. On the morning of January 19th, 2022, Reed's father made a 911 call expressing concern that she might overdose because she had a boatload of pills. The plaintiffs argue this proves she had access to a large amount of prescription medication at the time, and they want to know exactly what those pills were and if she took them. So, oh, perfect example of telling yourself, right? And did that get better or did it get worse? Otherwise, you know what? Here, give me just a second. I will put on something else that isn't in this stream then, and then you guys don't have to hear it. Because I thought I had like set it all up so where it doesn't do that, and now it's like reset itself so it does, and that's really like annoying. Let's see here. Oh, is this not the? There we go. Now I can hear it out, and you guys don't have to worry about it. So problem solved. All right. It's very loud over here. Okay. Let's see. Where was I? Okay. So then Reed tried to block their request because of HIPAA. The plaintiffs counter that privacy laws do not completely hide medical records in civil lawsuits if the information is directly related to the central issues. In this case, her level of impairment. They note that certain medical conditions can alter how the body processes alcohol, making these records necessary. Now, to protect her privacy, they suggest using court confidentiality orders rather than blocking the information entirely. Are they going to be able to use? I think they're going to be able to use her conviction for being drunk, right? Or, well, her DUI conviction. They're going to be able to bring that up, right? Or are they not allowed to? And that's why they want this? I don't know. Oh, I'm sorry to confuse you. Okay. So their next point, Reed argues that because she was already convicted of an OUI and her blood alcohol levels are public record, the plaintiffs don't need more information. The plaintiffs argue that her conviction proves her impairment is central to the case and that they have a right to know if medications made the impairment worse. Reed previously handed over bank statements from January 28th to the 29th, 2022, but she redacted significant portions of them. The plaintiffs are demanding unredacted versions because her spending habits, debts, and credits from those days will help them map out a precise timeline of where she went and what she had to drink. It's like they're just trying to solve something that's already been solved, but okay. All right. It's honestly, I mean, O'Keefe's need a new lawyer. Okay. Diller leaves a lot to be desired, is all I'm saying there. Now, July 3rd, the Judge Gilday, orders a decision and order on non-party Lieutenant Tully. Remember that guy? Motion to quash his subpoena and or for protective orders. So the judge denied the request to completely cancel the subpoena, meaning Lieutenant Tully must still comply with it. However, the judge did agree to narrow down and reduce the number of documents Lieutenant Tully is required to provide. Now, the judge criticized attorneys on both sides for a lack of communication. Like, Your Honor, you might as well get used to it. You probably should have consolidated all these cases, like her attorneys asked for in a hearing from like last year. And now here we are. The judge noted that Lieutenant Tully's lawyer should have filed official objections and held a required conference. Now, at the same time, the judge criticized Karen Reed's lawyer for repeatedly sending out overly broad subpoenas that place an unfair and expensive burden on the people receiving them. The judge pointed out that after the subpoena was issued, both sides had previously agreed to reschedule the compliance date to July 8th. The judge emphasized that agreements made between attorneys need to mean something and should be honored. Your Honor, you have said this to them numerous times and it has not happened. But okay. Now, there was an argument made that this subpoena was an attempt to bypass discovery limits in a separate federal court case. The judge rejected that argument, stating that while a judge has the power to manage the exchange of information, the federal case does not mean the state court case should be paused, especially since the state court's deadline for gathering evidence is quickly approaching. What a mess. And then the judge granted plaintiff's motion to compel Aiden Carney to hand over documents by July 13th. That would be Turtle Boy, who you all will meet next week. Well, not you won't be here, but I meant us covering him. Anyway, um, so then we go to July 6th. We have acknowledgement of various motions to clarify the record sent to all counsel of record for plaintiffs, defendants, and counsel for non-party Michael Proctor via email on the state. All right, so this is getting back to the judge being big mad that people are leaking things. So the court received multiple motions to clarify the record by Reed's legal team filed between June and July. The judge ruled that no action will be taken on these filings because Ms. Reed's team is using them incorrectly. Okay. The judge explained that a motion to clarify is only supposed to be used to ask the court to explain a confusing order or a ruling. It cannot be used to argue against remarks made by the judge, add new information, or simply get a party's opinion into the official record. He was like, no, we're not going to argue about it. Oh, well. Oh, you just watched his bus stop live? He does have a lot going on. Sounds like it. What a mess. What a mess. The court warned that any similar motions filed in the future will not even be officially docketed. If Reed's team wants to introduce new information discovered after late June, they must file a motion for reconsideration instead, following specific court rules. The judge noted that while the situation is not an emergency, the court is willing to set up a rushed hearing if both sides agree on a date. Okay, like they'll ever do that. And then the court previously ordered a pause on trying to gather evidence from Michael Proctor, and the judge has given the lawyers until July 9th to agree on a privacy deal to keep Proctor's personal information confidential. If they cannot agree by the deadline, the court will make its own rules regarding the information. And I don't think they're going to like that. So 7-6, defendant Karen Reed's notice concerning the MSP compliance with court orders. I bet. Sorry. That's weird. Um, anyway, I bet they're complying just super well. Just kidding, they're not. On June 26th, the judge ordered MSP to turn over a privilege log by July 3rd. As of the morning of July 6th, the state police had not provided the list required by the court. Surprise to nobody, Judge Gilday. Hello, is this your first day? Of course, they're not going to comply. Because MSP missed a deadline, Karen is asking the judge to step in and force the state police to hand over all the actual documents they are currently holding back. But why would they do that? We all know why. Also, on the same day, non-party case participant Lieutenant Brian Tully's motion for protective order governing depositions. So he's back, and he was like, "I have some more things I need to say." Lieutenant Tully is asking the court to set strict rules and boundaries for his deposition to protect his privacy and prevent his testimony from being leaked. He wants the court to rule that if his deposition goes forward, it must follow these specific conditions. Right. Is that because everybody in America hates you because you suck? Like hardcore? Yeah, it is. His testimony and the written transcript cannot be posted on social media, published publicly, or shared with anyone outside of the core legal teams involved in this case. Now, his testimony can only be used for this specific wrongful death lawsuit. Any questions or answers regarding his police personnel files or disciplinary records must be kept completely confidential. What don't you want us to see, Tolly? Hmm. The transcript of his questioning must be kept secret and filed under seal with the court. And anyone who breaks these rules should face legal penalties, such as being held in contempt of court. Well, I'll be. I don't understand why an upstanding officer would want everything to not go public. I wonder why that is. Hmm. Now, Lieutenant Tully's lawyers argue there are three major reasons why these protections are necessary. Wait, that's not the right one. Oh, I went way ahead in my slides, you guys. Oh, I'm sorry. Okay, here we go. I went too far. Karen has sued Tully personally in a separate federal civil rights case regarding the exact same investigation. Because formal questioning hasn't started in the federal case yet, Tully argues Reed's lawyers are trying to use this state lawsuit to get a sneak peek and gather information to use against him in the federal case. Oh, huh. Oh, the tables have turned. Oh, I think I forgot to do a slide. That's okay. So the court has already found that other secret legal documents in this case were leaked to his social media within 30 minutes of being filed. Even though that's not true, they're going to bring it up anyway. Because Tully is a high profile figure in this controversy because he fucking sucks, his lawyers argue that the public and social media are highly likely to immediately leak and twist his testimony to influence public opinion. It's like these guys didn't do it to themselves when they testified. I watched with my own eyes, but okay. And then Massachusetts state law already protects the confidentiality of law enforcement personnel and disciplinary records. So those protections should automatically apply here. I disagree, but we'll see. Oh, that was just the same one twice. I get very tired when I do these. All right. So finally, on the next day, July 7th, Judge Gilday orders a decision in order on defendant Karen Reed's motion to compel Nicole and Brian Albert, Jennifer and Matthew McCabe, Allie McCabe, and Brian Higgins to attend depositions and produce documents pursuant to non-party subpoenas. Now, if you don't recognize any of those names, I promise you, you are about to learn all of them. Especially going into the Hamvee Reed Turtle Boy one. But that is all of them at the top. They're kind of a big deal, and they also suck. So Karen filed a motion asking the court to force Ham to immediately, well, the McAlberts, to immediately provide dates to be deposed and to hand over requested documents. The judge noted some confusion and tension between the lawyers. No, never. It would never be the case. Two of the individuals had either already been questioned or had a date scheduled, making it unclear why they were included in the request. The judge pointed out that both sides were engaging in unnecessary legal fighting instead of cooperating on scheduling and handling specific objections to the document request. It's no surprise they're not getting along, Your Honor. And what's crazy is that Judge Gilday is also the judge on the Ham v. Reed and Turtle Boy. So it's like, sir, there's a reason they all literally hate each other. But sure. Now to resolve this conflict, where are we at? Karen's team must pick from the July dates already offered by the non-parties lawyers by July 9th. Let's see. The lawyer for the non-parties must explain. Oh, that's not right. Why are my slides all messed up? That's weird. Oh, well. Where was I? Rather than just make okay. The lawyer for the non-parties must explain their specific concerns about the document request rather than just making general objections by July 9th. Both lawyers must talk to each other and try to reach an agreement, narrow down the document request without the court getting involved. And if the lawyers cannot agree on the document request, they must each submit a one-page explanation of their positions to the court by July 13th. I'm sure that they're going to be able to put it all on one page, Your Honor. Like, oh, he's something. He just, I don't know. He thinks that should it work like a normal case? Sure. But this is not one of those. Excuse me. This is not one of those at all. I guess he has some hope. So then, non-party case participants, the MSP's emergency motion to extend deadline to comply with the June 26, 2026 court order. So the MSP and their lawyers claim they never received the court's order and only found out about the deadline this morning when Karen's attorney emailed them about it. What? Stop the games. Nuh-uh. They're asking the court for an emergency extension to push the deadline to July 14th. They said they reached out to Karen's team to see if they would agree to this extension, but they did not get a response. You're telling me the legal department for MSP didn't know that this was sent to them, even though they are so knee deep in shit from these lawsuits, not just this one, there's the other ones, her federal one, and then the other one she just filed in like June against MSP and Canton. And they just had no idea. Whatever. Stop. Okay. So then on July 8th, Christopher Maddie joins James Tuxbury in representing the Alberts, McCabes, and Brian Higgins. He is the one who talked in the last hearing that we listened to because Tuxbury was out on vacation or something. So that's that guy. He's now officially joined this one. So then we also have that defendant Karen Reed's emergency motion for reconsideration of order delaying the deposition of Michael Proctor, who also sucks. Now, Karen's legal team is asking the judge to reverse a decision that paused the deposition of Michael Proctor. They are treating this as an emergency because the next day of questioning is already scheduled for July 14th, and we're on July 8th. So, the judge believed an attorney in the case leaked confidential court information to the public, pointing to a post on X that shared details matching a private court filing. Now, the judge thought the X post appeared 30 minutes after the private court documents were emailed, but Reed's lawyers say the judge misread a timestamp caused by a time zone difference, UTC versus Eastern, which it gets the best of us, okay? We don't time zone here. The message was actually posted more than 3 hours before the court documents were even sent. Now, The information about Proctor was already being discussed online, on YouTube, and on social media up to 2 days before the private documents were filed. Therefore, no lawyer leaked it from the private filing. I'm sure the judge is going to love this. Reed's lawyers argue that pausing the questioning unfairly punishes Karen, who has already spent a lot of time and money preparing for this deposition. They also note that they tried to propose rules to keep the witnesses' medical and personal information private, but the other side has ignored them. Now, I will say that as I've been organizing all of the Hamvee, Reed, and Turtle Boy, the accusations that are in this case always thrown at Karen's Reed team for leaking things makes a lot more sense. I'm not saying they did or didn't, but that comes up a lot in the other lawsuit between her and Turtle Boy and their communication. So that's why everybody's always dogpiling and just being like, she's doing it, whether or not it's them or not. So that explains a lot of that to me, and it'll make more sense to you when we get into that. But because if you're like, why is it always them? That's why. So then on 7/9/2026, the opposition, Michael Proctor's opposition to the emergency motion for reconsideration. So Proctor argues against Reed's motion because sensitive court protected information about his deposition was leaked to the public. Specifically, Aiden Carney, Turtle Boy, posted on X details about Proctor allegedly having a panic attack and leaving the deposition within 30 minutes of it ending, suggesting someone inside was leaking live updates. More leaks, all the leaks. Where I most believe it was his ex-wife Lizzie. Who, Turtle Boy? Is that what you're talking about? Leaking? Who are you talking about, Leaking Gray? I don't recognize that name. Yet. I'm sure I will. I'm sure we all will soon. Now, Proctor highlights that he is just a witness, not a direct defendant in this case. He states that during 4.5 hours of questioning, Reed's lawyers didn't ask a single question about the actual death investigation or Reed's involvement. Instead, they focused entirely on the text messages from an unrelated lawsuit, which he claims was done just to harass him. This motherfucker. Like, what? They just want to bring up all of these really, truly horrible, deplorable things I said. That it's just I just don't like it. They're trying to harass me and embarrass me. Like what? Oh, fuck this guy. He really is the worst. If you don't know anything about this guy, you're gonna, and he is trash. You're craving leek soup. Leaking the confidential info about the panic attack, etc., what the judge chewed everyone out for. Oh, interesting. Interesting. Let's see. As you'll see, it's just all a bunch of messy shit with everything. So I'm excited to swim in it. Just to harass him. Okay, so next slide. If the court decides that his questioning must continue, Proctor asked the judge to limit any further sessions to a maximum of 3.5 hours. Aw, you don't want to be held accountable for the gross things that you said about civilians and witnesses and victims. Okay, okay, I get it. So you can talk all that shit, but then when it comes time, you don't want to deal with it. Typical, typical. Own it. Proctor's team requested assurances from Reed's lawyers that they would not share audio, video, or transcripts of his questioning with the media or social media. But Reed's team refused. Because of this, Proctor is asking the judge to officially order Reed's team to block any sharing of the deposition materials publicly. Someone call the ambulance, right? Oh, he's the worst, Mary. You are gonna hate. Wait till you, right? Because I think you're on my list of people who didn't watch these. This guy is gonna blow your mind. Actually, there's quite a bunch of testimony from the first trial that I haven't watched because we only rewatched some of them when there wasn't court for trial 2. So we'll be watching together for the first time. So yeah, you're not the only one. So you're gonna, you're gonna, if you thought the Murdaugh trial was whoa, this is times 1,000. All right, you're not prepared. You are not prepared. Um, it's amazing. It's wild. It's absolutely wild. Um, all right, where were we? And I'm not being hyperbolic. I've never seen anything like it. Oh, actually, he's right up there. He is right up there with being a shit bag. I don't know. I think he might be worse. I think he might be worse than Alec. Murdering aside, um, yes, Alex stole a bunch of money from wrongful death suits and people who were victims and deserved them. But this guy and the position that he was in, I, hmm, I don't know which one's worse. Maybe that's a poll we'll do when he goes to testify. Who's more of a shitbag, Michael Proctor or Alec Murdaugh? Both shitbags. All right, sorry, got distracted. 3.5 hours. Sorry, I got distracted in my note. Oh, okay. We're on to the next one. Sorry. All right. So this is a reply from Karen uh, to her reply in support of motion for reconsideration about Michael Proctor. Okay. So Reed is asking the court to rethink its decision to pause or delay the deposition of Proctor. Now, to explain how the information got out, Reed points to a public post on social media. So this is the text or the post that broke the judge, apparently. Is from Dex, who says he showed up and had a panic attack in the hall outside at 11:29 a.m., June 25th. Roxy McFly says, prediction or fact? Dex says, I saw it with my own eyes on a security camera, but cannot share it. So this is what the judge was big mad about, which I don't understand how he took it the way that he did, if that's what it is, but okay. So one post by Aiden Carney noted that Proctor had been seen outside being comforted by his lawyers, meaning that he was simply spotted in public. Another user posted about seeing Proctor having a panic attack on a security camera in a public hallway. Reed argues this proves the information came from public observation by outsiders, not a leak. So, okay. And Reed's lawyers reject claims that they behaved badly during the questioning. They point out that they actually accommodated Proctor by delaying the start of the session by 2.5 hours to help him out. He can say all the hateful shit he wants to all the time, but then here he is being a little bitch. Anyway, it's fine. We all hate this guy. Him out. Reed denies claims that her team refused to protect the privacy of the interview recordings and transcript. Her lawyers state they have consistently agreed to Proctor's requested privacy restrictions, as long as everyone else in the lawsuit signs off on them too. However, the plaintiffs have ignored the proposal. Why would Diller do that? Never. Yeah. Yeah. All right. So that puts us to July 10th, and we have a motion hearing to compel. So I'm going to take a quick little reading break and put this on. Why is it doing that? Mm, I think I have too many of these open. July 10th. Yes. Okay. I did have too many open. All right. So let's pop over here. Turn the closed caption on. This is a pretty short one. It's only about 12 minutes and 8 seconds. This is brought to you by the Trino channel, one of my favorite YouTube channels. She takes out all the sidebars and the breaks, all the stuff you can't hear, puts it all together so you can watch it in shorter time. And so please go subscribe to her channel over there, hit the notification bell, all of those fun things. I'm going to use this opportunity to take a quick bathroom break, but I will be listening. Okay, friends. All right.
Business at CNF McCarthy's et al.
Counsel want to identify themselves?
Good afternoon, Your Honor. Attorney Mark Diller.
No,
on behalf of the
Diller.
plaintiffs.
Afternoon.
Good afternoon, Attorney Christina Brahanti for the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Jim Tuxbury, attorney on behalf of third parties, Colin Albert, Brian Albert, Brian Higgins, Jen McCabe.
Oh, that's great.
Well, you're only here for Colin Albert today, so, all right.
Good afternoon, Your Honor. Damon Sedixon for Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Sarah Shipley for Karen Reed.
Good afternoon. So many of the other counsel, I think I had indicated, didn't have to appear because the issues don't really relate to them. The last time we were here on motions to compel was June 22nd. And at that time, counsel had indicated there would be a number of motions to compel forthcoming. And there were a number of them forthcoming. And I believe that I've addressed all of them except the plaintiff's motion to compel Ms. Reed's discovery. At the June 22nd hearing, we had a discussion with Attorney Matai relative to issues relative to Mr. Colin Albert. And I had indicated at that time, I thought it would be a great idea if more information was found out. So let's first hear from Attorney Tuxbury relative to the information about Mr. Colin Albert.
Certainly, Your Honor. I can read this, so I apologize, I'm going to read it down, what Mr. Attorney Matty did. So prior to the hearing, he had contacted the base asking about the inquiry that we discussed on the hearing on June 22nd. On June 23rd, he received a call from a private Jordan Rosa in the legal service department at Fort Jackson. And he indicated he was returning a call to place last week. He made the request to private Rosa about getting access to Mr. Albert, who, by the way, at this time, shortly after the hearing, he's now in basic training. So the 10-week basic training, the first 3 weeks was he was missing school. He's past that. He's now basic training at Fort Jackson. Private Rosa indicated that he was unaware of what process it would have. On June 26, 2026, Attorney Matty received a call from Sergeant Lucas Vaughn at the Trial Defense Services in Fort Jackson. He indicated he would ask about getting access to him from basic training for purpose of subpoena. He was told, quote, "That's not happening," is what the sergeant said. He speculated that the only possibility would be a 30-minute phone call. He said that the training regimen for basic training is very specific and condensed. He advised that eating and sleeping are the only breaks that the trainings receive. He said that following his graduation from basic training to advanced infantry training, which is what he's doing, he'll be a permanent party member at a duty station. He's more likely to have access for a deposition at that time. On June 26th, Attorney Matty received a correspondence from Colonel Jacqueline DeGain, basically suggesting that he would need the identity of Tom's commanding officer. We've now made several requests of Colonel DeGain for the identity of the commanding officer. Those have so far gone unanswered. So that's the current state now. We've had several calls with a private sergeant colonel. So far, don't have the information. It's been suggested to us that during basic training, they control their life from waking up to going to bed.
Yeah,
like
they
I said,
basically
the
told you to
breaks
fuck
they get are
yourself.
sleeping and eating. And it's part of the turning them into a soldier. So that's the kind of information we have now. I believe is in week 2 or 3 of basic training.
Okay, thank you. Attorney Seligson, is that news to you? Or have you had communications with?
I would think it's news to him, because he might not know, because we were preparing this to get, and then we got the news about coming today. So
Oh, and by the way, Tuxbury, this guy right here, that way, I think it is, he is the attorney for Ham. So we're going to hear a lot more from him for the next several months as we get into that. So he's something.
Kind of ran today. We had responded on the search terms. We did talk about search terms for Colin Albert.
Okay.
So we hadn't had a chance to fill it in.
Why don't you reduce that to writing and let Attorney Seligson know so he can be prepared to make an informed response.
Thank you, Your Honor.
Just talking about it at this time.
That's right. I wasn't aware of the mechanics of where he is, but we are working productively on the search terms and narrowing the scope of the subpoena.
Okay.
So that's working productively.
All right. Attorney Tuxbury, you're welcome to stay, but on a Friday afternoon, you're welcome to leave too.
I appreciate that, Your Honor. I think I'll take the invitation to depart.
Okay.
Enjoy the rest of your day, Your Honor. Thank you.
Thank you.
I think he has ADHD.
So the other
don't know if he
remaining
knows it,
motion
though.
is the plaintiff's motion to compel Ms. Reed to produce additional
Oh, the judge has
information
new
and
glasses.
discovery. And I've read everything. Mainly the issues relate to medical information and financial documents. And I guess I'll start with Attorney Seligson to ask you, given you know what the standard is because your office has quoted it a number of times in your motions to compel, that parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other attorney. Your opposition uses the term fishing expedition, which that's great if it's a criminal case, because that's where fishing expeditions are discouraged and not allowed under Rule 17 under the criminal rules. But this is a civil case. In Rule 26, it's
Oh,
very
no.
broad. So without getting into the specifics about the medical,
Not Rule
why
26.
isn't merely the provisions of Rule 26 applicable here? And why shouldn't they require production of the information the plaintiffs request?
Your
We're
Honor,
never
with
gonna
respect
skip it.
to seeking her medical records for a 2-year period, even though the term fishing expedition generally applies in a criminal case, I don't understand why they would need to understand her health in 2020, 2021.
How about 2022?
That's different. Perhaps if they narrowed it, we could reach an agreement about something in confidence. But
Did you have discussions about narrowing it? Did you two have discussions, or were you talking with someone else on these?
I spoke to Attorney Rosenberg.
He's still
but
Hang on. So the next issue relates to the financial documents. And there has been certain information provided.
Hi, Wing.
There's been certain information redacted. Have you had discussions about that?
we have had discussions, Judge. The redactions are for transactions that are not specifically asked for in the document request. So what we did was we produced the bank statements and credit card statements for the 2 dates that were asked. We blacked out and redacted account number and private information.
But somewhere you cited attorney-client privilege, I think, on that issue, which I had difficulty following.
Attorney-client privilege? I don't believe we assert attorney-client privilege, Your Honor.
Oh,
If
looks like
they
you
are-
did.
If there is a payment to counsel, then that's what that would pertain to. And if that's reflected on the
Somehow I don't think counsel were getting paid by credit card at that.
well,
Just a wild guess.
but there's a bank statement as well, Judge. So I don't have it in front of me with all transparency, but that would be the reason for it.
Those people.
The transactions that they asked for on the dates in question, we've given it to them. But just this broad wondering what else is out there and what else my client is spending her money on, it's not relevant, Judge. And she's entitled to some privacy on that front.
Right, but again, Rule 26 is so broad, it's not necessarily up to the party to say it's not relevant, because the standard is it might lead to the discovery of admissible evidence, right? So if we had a party every time just saying, well, it's not relevant, forget about it.
But if they're asking for transactions, if they ask for transactions on January 28th and January 29th, and the statement covers January 1st to January 31st, We've redacted out things that aren't specifically asked for.
All right, well, so we'll give Attorney Diller a chance. Do you believe that there was information redacted on the 2 days in question that is relevant?
Respectfully, I apologize. I don't have that redaction in front of me. I know that as it relates to anything on those 2 days, I believe there should be no redactions. And if things need to get filed that should be protected, we are amenable to redacting those
Don't
out.
have it in front of you. I'm sure you have a copy there.
I don't have it in front of me either, Your Honor. It's his motion.
Oh, come on, Diller.
The motion is, the interrogatory is a separate question from a production of document. So in the interrogatory still remains unanswered. The production of document is a separate whole issue that we have an outstanding issue for production documents.
I don't think the judge
I
would like that.
acknowledge that there was something that was turned over through production of documents relating to financial transactions. Our request asked them to articulate under oath, every one of the transactions that she had and the institutions that she filed them for those 2 days so that we can track both the whereabouts and also whether it's reasonably calculated, lead to discovery of admissible evidence, which is significant for just a 2-day period of time.
Okay.
In response to that, Your Honor, as we are entitled to under the rules, we are entitled to say, here are the documents that answer your question with appropriate redactions for things that are not asked for in the interrogatory.
Let's go back to the medical issue for a second. Doesn't sound like the two of you have spoken about the medical issues. And you suggested there might be a limited period of time that there could be some agreement on. So I'm going to ask counsel to go talk about it. And I'm going to ask counsel to keep in mind the reference by Mr. Diller to the testimony from the criminal case and the forensic scientist
Hi, Jupiter.
relative to medications.
Hope you're doing well today,
Cited
babe.
on page, it's in their reply, I think.
Page 2 of the reply, Your Honor.
No. I'm going to give you.
I was just thinking, while they want her bank statements, I feel like they're trying to imply that as soon as the day that this happened, that she hired a lawyer. I feel because they're like, oh, some of it's redacted for like, attorney-client like payments and stuff. And I think that the plaintiffs want to use, well, she hired a lawyer immediately that same day, which, okay. And I mean, they always like to use that all the time, but also, yeah, if you're involved in something like this, whether you've done something or not, you should always get a lawyer. But I think that's what they're not saying, but that's what they're looking for, I think, is to hold that against her. Hi, elbow feet. Hi, babes. Hope you're having a good day at work today.
A little time to go talk about that. And hopefully you'd also take the time to talk about the other financial records. All right? If you can't do it, you come back, I'll hear you, and I'll issue a decision at some point. Okay?
Okay,
Okay,
thank you.
that was a
Thank you.
pointless hearing. All we got from that
At
was
length. What are the parties asking me to do relative to the motion? Thanks for coming down. We'll see you next week.
Thank you, Judge. Your
all
Honor.
right. I don't know why it went backwards there. So all we learned is that the military told them basically to go fuck off. They're not going to be able to talk to Colin Albert for a little while until he gets done with basic training. And then, of course, there was arguments about, Karen's read medical or financial files and them wanting them, but nothing was decided. So that takes us back to our slideshow. We're now on July 10th, same day as that hearing. The judge previously asked the lawyers, oops, that's the wrong one. There we go. Previously asked the lawyers involved in the lawsuit to agree on a plan to keep private personal information confidential because they did not file an agreement by the deadline. The judge has decided he is stepping in. To nobody's surprise, except for him, I guess. The judge has written a draft rule stating that any recorded or written interview, testimony, depositions, including personal medical information uncovered during the sharing of evidence, cannot be shared with the public. It can only be used for this wrongful death lawsuit or the Ham v. Turtle Boy lawsuit. So, important to keep in mind, since he's on both of those. Now, the judge wants the lawyers to review this draft rule and submit written feedback limited to 1 page by July 13th. And the judge noted that while people in other related lawsuits can agree to follow similar rules, he will not issue orders for cases that are not officially assigned to him. So there's that. Now, then he has an endorsement on motion for reconsideration of order delaying the deposition of Michael Proctor, and he denied that. So Ms. Reed's attorneys are reminded of the provisions of the Superior Court. Oh, wait, no, that's not right. Sorry. I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party pending further orders of the court in opposition and a reply. Ms. Reed's attorneys are reminded of the provisions of Superior Court Rule 9A-A3 that a reply memorandum is to be limited to matters raised in the opposition which are not and could not have been anticipated and addressed in the moving party's initial memorandum. The motion misstates what I said. Not liking that. What I said was, I said what I said. What I said was orders of the court have been violated either directly or at the very least in spirit. I did not say what is stated in the motion, quote, that an attorney with an appearance in this case had violated the letter or spirit of the rule. I also did not state on the record that, quote, I had stayed the second day of Proctor's deposition, but rather stated that because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Okay, I don't know that's not the same thing, but okay. I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. However, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25, 2026 post on X. The motion for reconsideration is denied. So that's going back to all the X posts where he says I don't understand for the one that we just put up on the screen not that long ago about people seeing him outside. He's like, no. So then he has another order come through. The attorneys for Karen Reed submitted a document called a notice regarding parties conference to the court on July 9th. The judge rejected the document and ordered that it will not be added to the official court record or the docket, whatever you want to call it. So the judge explained that court rules only allow notice style documents in very specific situations. He noted that while he had previously told the lawyers to talk to each other to try to reach an agreement, he only asked them to file an actual agreement if they made one. He did not ask for a formal status update or notice about how the discussions were going. He's like, can you just come back to me with something of importance? I don't want to hear about how that's all going down there. And then let's see, we're going. The judge also questioned why the lawyers tried to include copies of their email conversations to the official court record. The judge told the lawyers not to file these types of notice documents in the future unless the court rules explicitly require them or he specifically asked for them. So basically, he's telling the lawyers to quit tattling on each other. Just do your effing jobs and quit sending me shit. When you get it all settled, come back. I don't need to read your emails. Everybody's dicking everybody around. Come back to me when it's important. So, hi, Mother Pugger. Just came in, no idea what's going on, but lovely to hear your voice. Oh, thanks. Good morning to you, babe. Well, we are wrapping up today the O'Keefe versus Karen Reed wrongful death lawsuit. Not wrapping up, catching up. It makes it sound like it's over. It's not. So that way we're all caught up in real time. And then next week, we're going to be going over the Higgins Albert McCabe versus Reed Turtleboy lawsuit and rewatching Karen's trial. So if you don't know anything about it, but you want to, make sure you come join me on the journey because I'm holding everybody's hands as we go through what is one of the craziest things for sure. Mary says, I don't know what happened. You thought it was so you didn't think anything of it. Oh, that's funny. All right. So let's see. That's the end of the judges one. Specifically asked for them. Okay. So then we're on to July 13th, where Karen reads, this is her response to the proposed order. So the court proposed a rule that would restrict how out of court, under oath depositions given in this lawsuit can be used. Karen's team is arguing against this proposal, calling it unfair and overly broad. So, under the judge's proposed rule that we just read about, the plaintiff suing Reed can use these statements in the two lawsuits against her. However, Reed would be banned from using those exact same statements to defend herself or prove her claims in the two related lawsuits where she is the one suing. Now, I don't know why the plaintiffs would be able to use it. The plaintiffs are the O'Keefe family, who are not part of the Reed v. Turtleboy or Ham v. Reed Turtleboy. They're only a part of this one, from my understanding. And then Karen has the one where she sues everybody. I don't think she's suing the O'Keefes for that. That one, maybe she is, but I don't think so. And that's the one that's in federal court. And then the other one's against the cops. So the plaintiffs, I don't understand that, but okay. So she's saying, but I won't be able to use these in mine. And her lawyers argue that standard legal rules normally allow prior under oath testimony to be used across related cases to stop people from changing their stories. That's similar, I think, to the argument that they were using in South Carolina for Murdaugh and whether or not they can use his previous testimony from the first trial against him. That's their argument for that. Now, the court suggested this restriction because of concerns that a previous order to keep certain information private was violated. Reed's team insists they have already proven they did not break the rules, that the judge refuses to believe because I don't think he wants to admit that he was wrong. But Reed offered a compromise, though. Limit the use of all sworn statements and personal medical information strictly to the 4 related ongoing lawsuits, ensuring they aren't leaked to the public. And the plaintiffs, though, rejected this idea, but Reed is still open to it because, of course, the plaintiffs did. Of course, Stiller did. If the judge decides to put a restriction in place anyway, Reed asked the court to promise that if anyone is accused of breaking the rule, they will get a formal notice and a fair chance to defend themselves before facing any punishments or fines. So also on this day, the plaintiffs request for clarification on the proposed discovery order. So the plaintiffs are asking for clarification regarding the judge's discovery rule of secrecy and was worried it will hurt their case. Specifically, they want the judge to clarify 3 main concerns so they can follow the rules while still doing their jobs. Okay. So using testimony to question other witnesses. The lawyers want to make sure they are allowed to show one witness's answers to another witness to see if people are lying or changing their stories. That's fair. You know what? I'll give you this, Diller. These are fair questions. Then investigating outside of formal questioning. So because they won't formally question everyone involved, the lawyers need to be able to ask other potential witnesses about statements made by Karen Reed and others to see if those statements are true. And then submitting evidence to the court. The lawyers are worried the rule might prevent them from attaching testimony to their official court arguments. They're asking if the judge wants them to file these documents under seal, especially regarding medical records about Karen Reed's medical condition. information that has already been discussed publicly in previous criminal trials and media coverage. So to resolve these issues, the plaintiffs are asking the judge for a formal hearing to talk it through. And then, side note, both C.F. McCarthy's and the Waterfall Bar and Grill, who remembered they were in this lawsuit, the two bars they went to that night that are just there. They don't really file or do anything, but they have zero objections to the judge's discovery order. So that's great that they chimed in. They're like, we don't object because we just want you all to forget that we're here. So then on July 15th, 2026, Gilday comes with another order, and the judge rules that any deposition testimony, which includes written transcripts, audio, or video of witnesses being questioned, and private medical information collected during this lawsuit, can only be used for this specific case and the Ham v. Reed Turtle Boy lawsuit. Now, this information cannot be shared publicly or posted on social media, and these rules do not stop lawyers from using past testimony standardly during trials to challenge a witness's truthfulness, or using it in other depositions for these cases, or investigating whether someone is lying under oath. But he says, anyone who violates this order will be given notice and a chance to explain themselves before the judge issues sanctions. And additionally, a temporary stay that had previously stopped the lawyers from gathering evidence from outside witnesses, the non-parties, has been lifted, which is like the day after they had scheduled Proctor's next deposition, but I don't know if that went through or not. All right. So we now have another status hearing. This one is even shorter, but we're in Zoom land. And this is a status hearing. It's about 7 minutes and 20 seconds, again, from the trial channel. Please go subscribe to them, where they have all of the best trial breakdowns, I think. All right, let's get into this one.
May I proceed?
And also, if you are watching and you don't know what we're talking about, we got a whole playlist on here to catch you up on all the O'Keefe stuff. So go check that out afterwards if you're not sure. I read all the documents, so you don't have to.
Go right ahead.
Good morning, everyone. The matter before the court is Civil Action 2483 CV 00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CNF McCarthy's et al. Your Honor, all parties are...
Why is he always like this? Oh, I love the Zoom call so much. I'm convinced Diller is a meerkat. Just it's so funny. Okay.
Zoom for the plaintiffs, we have attorney Daniel Buck and attorney Mark Diller. For defendant CNF McCarthy's, we have attorney Tamara Holstag. For defendant Waterfall, we have attorney John Dealey. And for defendant Reed, we have attorneys Sharon.
He's like, I don't like how the glasses
Damon
look.
Seligson and Aaron Rosenberg.
Morning, everyone.
Morning.
Who would like,
Morning, Your Honor.
who would like to start out? Well, why don't we start with the plaintiffs? What do you have to report relative to discovery and depositions?
12 depositions have occurred, and there are depositions on the calendar every day for the duration of the discovery period.
Oh, damn. Which was the 17th of August.
Okay. Any issues having people appear?
Your Honor, for Ms. Reed, this is Attorney Rosenberg. We've obviously filed a number of motions, but I don't believe there are any that are either outstanding via 9A or before Your Honor that relate to anyone appearing for deposition.
Yeah, I don't think I have any outstanding motions to compel anyone at this point in time. I think I took care of all of them.
Oh,
I think that's right.
the McAlberts had to
Okay.
comply?
We have
Okay.
everybody subpoenaed, Your Honor, and I don't have reason to believe that they won't appear yet, but if I come across that and we need the court's intervention, we'll file that forthwith.
Okay.
Cool.
Attorney Rosenberg, how many depositions does Ms. Reed have scheduled in the next month?
So we've taken, I believe, 6 and a portion. And then we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9, all scheduled within the current discovery period.
Oh. Well, they made some progress.
Attorney Daly?
Morning, Your Honor. For Waterfall, we have 3 depositions scheduled. We've been attending all the depositions as they've occurred, and we haven't encountered any problems yet with attendance or otherwise.
We're just here because we have to be.
Attorney Holtzflag?
Good morning, Your Honor. We have 4 depositions scheduled for late July and August, and I too have not had any issues yet. In fact, counsel for certain parties have already reached out and been cooperative.
Okay.
Or I should say not parties, but deponents.
Okay.
Okay, thank you. Is anyone considering filing a dispositive motion?
No.
Possibly.
Oh.
Possibly.
But it's going to depend on how discovery bears out, of course, Your Honor.
Same goes for Waterfall, Your Honor. It's going to depend on how the depositions go.
Yeah,
Look up what that
we've
means
been
again.
focusing on getting the depositions done, frankly, Your Honor. So I would say the same thing.
Okay.
Okay. So just for the record, dispositive motion is a formal request asking a court to completely or partially end a lawsuit before it reaches for further trial. So both the bars, Tamara, she's representing one of the bars, and then Daly down here is representing the other bar. Right, because he just said that they both might file. Like, well, we don't want to be here for this. So that's interesting.
All right, well, let's get back together on, say, August 6th. Are the depots scheduled that day?
Probably, but we can probably split our time.
Yeah, same time, August 6th, 9:45 a.m.
We have Waterfall.
Do you have a deposition scheduled today at 10?
We do not, Your Honor.
Yeah, no, we don't.
We did, but it's been taken off the calendar.
Right. Don't.
I selfishly put them on at 9:45 when you have a 10 o'clock deposition, so it won't take so long. So let me know if they get canceled. Okay.
I would do
anything else anyone
Got
wants
hard
to
out.
bring up?
I just wanted guidance, Your Honor, on how the court wants us to address what we addressed at sidebar.
Well,
regarding the privileges.
I think the way, from what I read, it appeared that there was still some discussion going on. And it didn't appear to me that an end had been reached in those discussions. So if I am incorrect and an end has been met, then file a motion. And if an end has not been reached, then keep talking.
Will do, Your Honor.
I don't appreciate
All
the
right,
code
I
words.
just wanted, for purposes, we were just trying to accelerate given the short turnaround as it relates to the discovery period, to the extent that there is going to be discovery that's being withheld that we are entitled to. I appreciate we'll have those dialogues, Your Honor, but then my understanding was we were teeing that issue up to try to have some guidance on it so that if there's going to be further disclosures that are necessary pursuant to that disagreement that we raised at sidebar, it would happen timely so that we could use that data for depositions.
Your Honor, if just very briefly, what we're talking about right now is the form of the privilege log. These are privileges that
they're talking about MSP.
Objections we made in October of last year.
Norfolk.
So I'm happy to speak with Mr. Diller right now at the end of this conference and find out what exactly he thinks he needs and try to get it to him. That's what I.
All right. So if everyone's willing, whoever needs to is willing to keep talking, that's great. And as far as teeing it up, I didn't anticipate it in our discussion that I gave an indication that we needed to have it done by today. But I understand the time issues, and if it gets to a point where you think it rises to the level of an emergency, I don't really know how it could, but you have the rules that you can avail yourself of and get the matter before me.
Okay, thank you, Your Honor.
Are they talking
Okay.
about Karen's stuff? now?
Thank you, everyone. Have a nice day.
Thank
You too.
Thank you.
Thank you, Your
Your
Honor.
Honor.
I feel like
Okay.
they're talking about like MSP or something, or the district attorney's office. It could be Karen. I don't know. Who knows? Talking code, and I don't like it. We're nosy. We need to know. All right. So back to the slideshow. There's going to be a lot of this. We're almost done, actually, friends. Isn't that crazy? So then on July 24th, 2026, that hearing was on the, in July 16th. Then on the 24th, Judge Gilday has another order. I am informed that there is a dispute between counsel for Ms. Reed and the MSP relative to whether the MSP has established that certain withheld documents constitute protected work product. They've been arguing about this for like months now. Counsel for the MSP is requested to provide a copy of the privilege log, and both counsel are to provide a one-page document setting forth their respective positions. I will review and make a decision or schedule the matter for a hearing. Now, the 27th, 3 days later, Karen reads memorandum in support of motion to complete the record and for clarification of docketing procedures. So the defense wants 2 letters from June 26 and June 26, 2026 to be officially added to the court's docket. One letter was from the lawyer of Michael Proctor, and the other was the defense's response. This is when the judge was all big mad about information being leaked out. Now, even though the judge used the information in these letters to halt questioning of Mr. Proctor, the letters themselves are missing from the original record. Now, the defense notes that if the letters are not officially in the record, then no higher court can look at them in the future, if they go to appeals and whatnot, right? So they do not mind if the court keeps the content of these letters sealed as long as the record officially shows they exist. The defense is asking the judge to clearly explain the rules and procedures for how their paperwork is accepted and logged by the clerk's office. They state that their legal team has repeatedly run into roadblocks when trying to submit documents. Oh my gosh, I'm going to have a rant. Speaking of the court docket site, whoever is scanning these docs, they need somebody else. All right. Because I go through, I get them all, I write how many pages, and there were so many where they were like, this document is like 700 pages. There was one that said it was over 3,000 pages. And I was like, holy fuck. Like, what is in that? It's just the same 4 to 6 pages repeated over and over and over and over again. On several of the documents. I'm just like, who's doing this? Who's scanning and putting these in? I've never seen, of course, we're in Massachusetts, but I mean, I go through court docs all the time from, the actual like court sites. Never see this happen with this many consistently with all of them. I don't know who's doing it, but they're not good at their job. Okay, where was I at? The defense is asking the judge to explain the rules. Okay, I did that. In June, an electronic filing was left in limbo for a month, and the clerk's office told them the document had been locked by the court. In July, a delivery courier spent an hour waiting at the courthouse to get a stamped copy of a hand-delivered document, only to be told it could not be officially logged until the judge personally reviewed and approved it. The defense emphasizes that they are not trying to argue with the judge's previous decisions or question the judge's or the court's ultimate power to reject documents. Instead, they simply want to understand the system being used so they can follow the court's expectations and ensure the case record remains accurate and complete, because it is a shit show over there. So, hello, 3 clerk Monty. Look up if the judge is easily. Oh, well, I'll have to look into that later. Thank you for joining us. So yeah, that the documents pages, it's wild. It is wild over there. They can't seem to do anything right in Massachusetts. Massachusetts. I do love the people of Massachusetts. They'll agree. We met lots of good friends while watching this trial together, but damn, they are a mess over there. All right, so on July 30th, defendant Karen Reed's one-page explanation of remaining disputes regarding the motion to compel the MSP to produce documents. So Reed is asking the court to order MSP to hand over communications between the police and the Norfolk District Attorney's Office. These documents are emails and messages about Karen Reed's criminal prosecution and the investigation into the death of John O'Keefe. The MSP have withheld them, claiming they are legally protected or confidential. How convenient. Reed argues MSP cannot just hide every single conversation they had with the DA's office without a specific valid reason. Now, under the law, it is the police's responsibility to prove why these documents should be kept secret. And Reed claims they failed to do so for nearly a year, which, okay, this is exactly what they were talking about at the end of that last status hearing, was them not playing along here. She states that she has a substantial need for these records to defend herself against the plaintiff's claims that she is pushing a false narrative that you're going to hear a lot about in Ham v. Reed Turtle Boy. Because Reed argues that the police investigation was biased and corrupt, she believes these communications are directly relevant and necessary to prove the true nature of how the police handled the investigation. And then the Massachusetts State Police replied back. They want the judge to reject Karen's request. MSP says hold back these specific emails because they are protected by legal privilege. They argue that the documents contain attorney work product and attorney-client communications. They also argue Karen has not shown a substantial need for these specific emails and that legal protection for these type of documents remain in place even after the original legal case they were created for has ended. So that brings us to the next status conference. This one takes place on August 6th, 2026. I think this is MSPs in here, maybe. I don't know. We'll see. Oh, look, there's Lincoln Rose, who we don't get to see very often. I think he's representing one of the bars, right? Something like that. All right, let's get into this one, shall we? This one's about 21 minutes long.
Everyone, the matter before the court is civil
Gonna go
action
potty real quick
2483
while they do
CV
that.
00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph.
Just pause for a second for 3 Clerk Monty. Massachusetts is worth saving. Great people, great place. Problem is every institution is fully captured in doing the bidding of corrupt federal entities. I agree with you. I agree with you. Everyone that we've met from covering this and watching the trial, the past that's from Massachusetts, amazing, great people. Their systems, oh boy, what a mess. And I'm glad that a lot of people in Massachusetts are being like more aware of all this corrupt bullshit. But hi, Sam. Yes, thank you. I don't wear this one very often. So thank you, Sam. All right, back to this. I'm going to go to the bathroom real quick.
O'Keefe III et al. Versus CNC Hospitality LLC doing business as C&F McCarthy's et al. Your Honor, for the plaintiffs, we have attorneys Daniel Buck and Mark Diller present by way of Zoom. For the defendant C&F McCarthy, we have attorneys Tamara Holstag and Lincoln Rose. For defendant Waterfall, we have attorney John Dealey and Asset, I believe. And for defendant Reed, we have attorney Sarah Shipley and Aaron Rosenberg.
Good afternoon, everyone. Good morning, excuse me. So Attorney Dillard, do you want me to tell me your perspective of discovery at this point?
Sure, Your Honor. 25 depositions have occurred. There are still another 21 that are outstanding. A number of depositions had been noticed to occur that everybody was prepared to occur, and they were canceled at the 11th hour. I believe mostly by witnesses, but they're still on the docket to be occurring. There were several substantive depositions that are pretty significant to the parties in this case that ended up being canceled at the 11th hour that still need to happen. And I expect that from those depositions,
Oh, I wonder who that could
there
be.
will be follow-up questions that require further discovery.
When you say substantive depositions, tell me which depositions you're referring to.
Well, notably, Aidan Carney, Your Honor, failed to attend his deposition, which was scheduled on the 30th. We're preparing a motion to compel for sanctions. He then went on his live stream that evening and said that
I don't need to hear all the details. Just
all right.
take your motion filed.
Yeah, so that hasn't happened yet. Miss Reed's suspended deposition has not finalized. It was supposed to have occurred, and for logistics reasons between all the parties, that was moved to another future date, so it hasn't occurred yet. There's also, I know that we're still have a 30B6 of one of the bars that is outstanding.
Is it scheduled?
It was scheduled and it's come off the calendar, but is being rescheduled based on availability, and that's being discussed between the parties.
Okay. Do you want to offer anything else?
Okay. Oh, terrible. I was in court that day. He
I'm
was supposed
sure
to
I
do his
could offer a
deposition.
lot, but for now, that's probably a good stopping point.
Okay. Attorney Rosenberg.
Thank you, Your Honor. So from our perspective, we've taken 13 depositions. We have 3 more that are scheduled for dates certain before or including the 17th. We then have only 6 depositions that have yet to be scheduled because of witness issues. One of those obviously is Colin Albert, as you're aware. The others are just logistics with witness availability. Just to kind of get ahead of what I think we're going to be discussing.
Of course, Lady in Gray.
Our proposal is that we're close, and we think we're going to get almost all the way there by the 17th. We would not object to parties doing some cleanup depositions, obviously, in the week or 2 that follow the 17th by agreement. And I doubt that anyone would object to that. We've spoken with the other defendants about that, and my understanding is they're okay with that. So I don't think we need an extension of your deadline. We've worked hard to get there, and I think we've gotten, at least from my perspective, close enough. I'm sure you wish we'd gotten fully there, but I think we're very close. So I would ask we stick with the deadline.
They got more done than I thought they would.
Deadlines thereafter, and we continue to move the case forward.
Okay. On behalf of McCarthy's.
Good morning, Your Honor. I would agree that the parties have made a ton of progress. as has been discussed, over 24 depositions have occurred in a short period of time. There are several more to go. I count 17 left to go. Of those, only 3 of them are noticed depositions on behalf of CF McCarthy's, one of which is scheduled to take place on August 11th within the current timeline and tracking order deadline. The other 2 are 2 folks that were scheduled to go forward, and then there was a sudden family emergency, which we of course accommodated, and that just needs to be rescheduled with our counsel, and we're actively doing that. I also echo Mr. Rosenberg's comments and Mark's. The parties have been working and talking amongst each other about whether there needs to be any extension of the discovery deadline. We're fine if other people in the court are okay with us completing discovery that's already been pending shortly after the discovery deadline and trying to wrap everything up. I do note that some of that does seem to depend, though, on third parties, some of which haven't been as necessarily compliant. So I'm not sure how that is going to all track. I can't predict the future there. For CF McCarthy's, I also agree with Mr. Rosenberg that we need some firm deadlines after the close of discovery for staggered plaintiff's expert disclosures and also then defendant's expert disclosures, probably 45 days after the plaintiff's. And then we'd also request, Your Honor, that after all that has occurred, that the court set down a reasonable date for Rule 56 motions in the event that we need to bring such a motion to the court's attention.
So that would put expert stuff
on behalf
by
of Waterfall.
January, I think.
Good morning, Your Honor.
30
I-
September.
A lot of what I was going to say has
November.
already been said, Your Honor. On behalf of Waterfall, we have 3 more depositions scheduled for us to be principal people taking them. They're scheduled for today, for Monday, and for the following Monday. But obviously, we are participating and want to be involved and participate in the depositions that are still outstanding. So it seems pretty clear there's going to need to be some more time, and we're trying to work it out between us to get this stuff accomplished. We also agree with regard to McCarthy's indication that we would like to have or see the court amend the deadlines or add deadlines for expert disclosures, staggered disclosures, as well as push out the Rule 56 deadline beyond those expert disclosures so that we get the events in the right order.
I wonder if they're going to bring experts from the trial. Do you think Diller is going to be? No, surely they're not going to bring Aperture back. I can't wait to see these expert lists, though.
So we can bring motions as necessary before the court, Your Honor.
Maybe we'll get ARCA
Thank
again.
you. Did all parties propound interrogatories?
Yes.
Okay.
Yes, Your Honor.
Yes, Your
I
Honor.
assume there were expert interrogatories?
I actually don't believe there were expert interrogatories from the plaintiff. We, for Ms. Reed, certainly served expert interrogatories.
Okay, so if there are expert interrogatories propounded, presumably the answers would have identified some experts. Am I correct?
Well, I can respond as to the plaintiff's answer to ours. They objected that it was premature when it was served, and I believe indicated that they would amend that, but have not done so yet.
So they don't even know who they are yet? Okay. Diller.
Okay.
I'm not going to say
I
anything.
know we have.
I didn't hear that, I'm sorry.
I was just going to say, Your Honor, we also propounded expert interrogatories, and I believe the response is similar to what Attorney Rosenberg just had said from the plaintiff.
Okay, well, I mean, the tracking order doesn't talk about expert disclosures. Tracking order talks about discovery. And
If they bring
discovery
back
of experts,
Shannon, oh my God.
the identity, et cetera, is not only allowed, but it's required responses.
Yeah, and Your Honor, if that from our perspective, from Ms. Reed's perspective, if your direction is that supplementation to an already served interrogatory should happen by the close of discovery, that's fine with us.
For CF McCarthy's,
Okay.
Your Honor, I would say that decisions relative to experts on our part may go hand in hand with the defendants, but also need to go hand in hand with the completion of discovery. So I would say that we're more than happy to, of course, timely disclose and, expert interrogatories to all parties, and certainly intend to. But that is still in process for us.
Just to be clear, Your Honor, I said that because, as I said, the plaintiffs have not served an expert interrogatory on the defendants. So the defendants don't have an interrogatory answer to supplement. Only the plaintiffs do. And they have multiple ones.
Oh,
We'll serve additional interrogatories.
Well, Your Honor, that.
oh, look at that zoom in into Rose there.
Additional interrogatories in accordance with the current discovery deadline.
I believe that this current discovery deadline is the 17th of August.
Right, but that's not to serve discovery. That's for discovery to be completed.
I'll let you folks debate all that offline, okay?
Okay.
Okay.
Anyone else
Not
offer anything else relative to discovery?
As it relates to discovery, Your Honor, we had requested and have reached out to the defendants to do an inspection of the vehicle with our experts. So as it relates to disclosure of experts, there are a lot of experts that will be disclosed ultimately in this case, though there is also a lot of data that's still being acquired through the discovery process that we are in need of before we can get to expert disclosures, though we are well aware of the need to do expert disclosures.
Your Honor, I would just reiterate on Ms. Reed's behalf that we've had a discovery deadline that was more than a year after the case was filed by the plaintiffs, more than a year after the stay of discovery of Ms. Reed, what has expired. And everyone's known there need to be experts, obviously. And so I think that work needed to have been done. If there's going to be a motion about this, I agree with you. I don't need to take your time to argue it right now. We can argue it if it comes to pass.
But Your Honor, may I respond briefly to that?
Sure.
The plaintiffs, though, when the criminal trial ended, we served discovery within 30 days upon the defendants. The plaintiffs did not obtain any of the documents, which were well over 1 million pages in digital and have continued to accrue since then.
Mm-hmm.
As you know, until sometime in or around January, and had difficulty accessing those
Oh my God, we're back
documents.
on this again, Tiller.
To suggest that we were able to procure experts and start working up the case before we had access to the very materials that the Reed team had access to since the criminal matters were going on. We didn't have that luxury. We were not the Commonwealth. Nobody would release to us all of that data while the criminal matter was pending, and then motion practice ensued, or there was discovery practice. And so this court is aware that initially there was a motion to dismiss filed that was heard and presided over last October. At that hearing, there was an announcement that we were going to be adding 10 new parties to this case, and that was to be briefed. That period of briefing occurred over the next 2 months, at which time, after the briefing, that was withdrawn. And it was plaintiff's position at that time that if they were going to add 10 new parties, it wasn't prudent for us to start engaging and and start pushing the parties to turn over the discovery if we're adding 10 new parties. Then when that came off the table.
I'm sorry, because this case has already played out in court 2 times. All right. I understand that they didn't get all the discovery from Karen and they didn't get it for Norfolk and all of that. But like, you should already have some kind of experts or the basic what experts I'm going to need for this trial, regardless. I don't understand why he's like, well, we don't know yet. We don't know who we want to call. I mean, yes, you may not know their specific names, but like, I'm going to need this kind of expert. I'm going to need this kind of expert. This one, like, stop it, Diller. Stop it.
Those other parties were added to separate lawsuits. We then started to receive discovery, but we had difficulty accessing that discovery. So I do appreciate the amount of time that this case has been pending, but to suggest that we were in the driver's seat since last July, that's not the case.
You're
We've
the
been
plaintiff, though,
trying
sir.
to catch up and get access to all the materials, and they were significant. In fact, I can also share with you, Your Honor, that the bars didn't have access to their own videos until we were able to get them through this discovery practice. And so there, in deference to the bars, it wasn't fair for us to force them into discovery when they didn't have access as well
Oh, my
to all of
goodness.
the materials that had been outstanding because of the criminal case and were not being disclosed. So I do appreciate Attorney Rosenberg's position and understand that the Reed team feels as if they could be super diligent because they've had this case for 4 years. We've only had it in earnest since the end of 2025 into the
You filed this in 2024 in between the two trials. You're the one who brought the case. You are the plaintiff. You can't be like, Bobby, this is so unfair. You're the one who brought the case. And it's, you damn well knew what all it entailed. Like, it's been the biggest case covered in like the last 3 years. And you're like, well, I didn't know it was going to be this much of a headache and this much of discovery and whatnot. I didn't know. What? Come
beginning
on.
of 2026 with regard to access to all the data that needs to be digested
Like,
and
what did he think
organize
it was going to
experts
be?
for.
Your Honor, I missed Attorney Diller, I think, disagrees with me, but I still don't feel the need to go back and forth when there's no motion before you unless you want me to address anything.
I'm all set.
Okay.
Attorney Diller, when are you going to file the motion relative to the witness that didn't show up?
It'll be done today, Your Honor. In full transparency, that witness has disclosed that he is willing to show up, but I will tell you, I would prefer to have an order of the court so that if it's skipped again,
It's Turtle Boy.
that there
That's who
is
it is.
something that puts him, forces him to actually go forward with the deposition. So
It's him.
You say it's going to be prepared today, so it hasn't been sent out?
it hasn't been served 9A.
Do any of the other parties object to the motion?
Well, I don't know what the motion's going to say, Your Honor. I'm happy to.
The motion is probably going to seek compelling the witness to appear. Anyone object to that?
If that's the entirety of the motion, then no.
Your Honor, on behalf of
Let's say the
Waterfall, we would not object.
On behalf of CF McCarthy's, we would not object either, Your Honor.
All right, so let's assume the motion seeks sanctions. Are any of the other parties going to object to that?
I would say it depends what the sanctions are, there's a possibility we might not take a position on it. I can't really answer that without knowing what they're asking for.
Why would you possibly oppose a request to sanction a non-party that you have
$10 million.
nothing to do with?
But I didn't say that I necessarily would, Your Honor. I said I don't know what the sanctions that they are seeking are. And so sanctions can obviously be a lot of things. And there may be an argument that the sanctions that are sought are not appropriate. I don't know. I'm in a vacuum. I can't tell you that, yes.
If Aiden Carney doesn't show up, I want to release bees on him, Your Honor. I think that should be his punishment, a bag of bees. Something completely irrelevant. Why not? Look at it. Look at his face. Oh, he is going to make the best thumbnails. Well, Buffy's going to make the best thumbnails, but his face, top notch. Love it.
I would agree to whatever sanctions they ask for.
Okay, so everyone agrees that a witness that didn't appear, it would be appropriate for an order to issue compelling that witness to appear. Is that correct?
Correct.
Attorney Dillard, do you agree with that?
Yes, Your Honor.
Rosenberg, do you?
Yes.
Okay.
That it does.
We're having a little screen problem here, so I lost it. Here we go. Attorney Holstad, do you agree to that?
I do, Your Honor.
Attorney Daly, do you agree to that?
Yes, Your Honor.
What about Lincoln Rose? Why is he even here?
So how about I issue an order compelling the witness to appear? When do the parties want the witness to appear for deposition?
It's Mr. Diller's witness, so.
He's currently under subpoena for a rescheduled deposition to occur on the 17th. I will share with you that he has reached out and say that he's not available on the 17th and has given other dates. The only dates that
I'll tell you what, Attorney Dillard. You can file your motion to compel the witness to appear outside of 9A, given that all of the parties don't object to that.
Okay.
You can serve your motion for sanctions or whatever else you're looking for under 9A, and we'll wait to hear Attorney Rosenberg's perspective on potential sanctions. So file your motion today.
I will.
So the reason why, so because we haven't with Turtle Boys, we'll start that journey next week. But he also has criminal charges pending related to this whole thing with, I don't want to get them all wrong, but it's like witness tampering, picketing, something else. And so even by him showing up to these depositions, he pretty much is going to plead the fifth to most of them because he is smart. He has attorneys and he's facing criminal charges still. We'll get into all of those at a later date, but that's why, like, it's like, okay, but like, you're not going to get very much from these depositions because what reasonable person would?
Yeah.
Okay.
Telling the witness.
And as it relates to discovery, taking the deposition, if it has to occur outside of the discovery deadline, given our current situation.
Yeah.
I just want to make sure that nobody's going to object to that.
From Ms. Reed's standpoint.
Yeah, we don't need to do that here. I'll tell you, the court's never going to object to attorneys working together to get things done that are supposed to be done.
Okay,
He's like, I've been begging you guys.
Anything else? All right. Thank you, everyone.
Thank you.
Have a good day.
Thanks.
Sure. Bye.
Thank you, Your Honor.
Yeah, Lady and Great. They all know that he's just going to plead the fifth. This is just another way for them to like publicly vilify him. And listen, we're going to get into Turtle Boy next week. Some of y'all are not going to like him. All right, I'll let y'all know right now. Some of y'all are not going to like him and things he says and how he says things. But from what I've observed trying to put this together, there is a lot of scapegoating going along. And I feel like that's also what's happening here. Is like they know damn well he can't answer anything. Why would he? I mean, they're hoping, I think, that he would mess up, but I really don't think he would. But anyway, so publicly vilify and cost him money. That's all. If you want my opinion about things, it's that, and because he's not super entirely relevant to the plaintiffs. I mean, yeah, I guess so. If they're saying that there was like this false narrative, you'll understand more for those that don't know when we get into the defamation lawsuit next week. But this costs thousands of dollars to have your lawyer there with you for a deposition. So the more money they siphon away from Aiden, the less money he's going to have for the defamation lawsuit, and the less money he's going to have for these criminal charges he has pending, which I think are significant prison years he's facing. I don't know the number off the top of my head, but I feel like I was like, oh shit. I want to say it was like 30 years or 40 something. Maybe not. I might be confusing it with Murdoch because I was laying them out together at the same time. But either way, that's why at the beginning of the O'Keefe lawsuit here, when they filed this, Karen's in the middle of 2 criminal trials because they decided to retry her, and the judge stays her testimony, discovery, everything in this lawsuit because she's not going to say anything because she's having a second criminal trial. So I don't know what they're expecting out of him. I mean, come on. Let's be like for real, for real. Um, he's not really but he is if they're saying that like Karen is doing this false narrative, that she's actually the one who did kill, and so he actually is relevant now that I think about it. Not as relevant as the defamation lawsuit that he's now a part of with Reed. But this one, yeah, it kind of does fit into one of their claims against Karen Reed. And it was false narrative for one of their intentional emotional infliction of distress claims. So 40 years. Okay, yeah, I thought he was facing some very serious, some serious time there. And they want nothing more than to lock him up in prison and be done with him. Nothing more than that. So, all right. So back to our slideshow. We're almost through this, you guys. All right. So that was August 6th. That hearing was also on August 6th. Judge Gilday does an endorsement on the memorandum in support of motion to complete the record and for clarification of docketing procedures. Other action taken, a hearing to consider the impoundment of the reference documents shall be held by Zoom on August 30th, 2026 at 9:45 a.m. Counsel other than Ms. Reed's and Mr. Proctor's are excused from appearing if they do not wish to appear. The motion is otherwise denied. So he's making them come in about those letters that the lawyers wrote and whether or not they should be on the docket and under seal. We're going to have a hearing about that. It really could have been an email, you'll see, but he wants a hearing. So then he also has another order regarding the motion to compel MSP to produce documents. The judge wants both sides to submit more information to support their arguments. He specifically wants them to look at a previous court case, the Attorney General versus Facebook, to help guide them on how legal privileges work. I don't know anything about that, so that would be interesting. The judge wants MSP to explain why it thinks the documents should be kept secret. Specifically, the MSP needs to address Karen's claim that the police have not yet proven, the documents are legally protected. And then the judge wants Reed to explain why she needs them. Specifically, she needs to address the MSP's claim that she hasn't shown a genuine, substantial need for them yet. And to make things clearer, the judge ordered the MSP to provide an alphabetical list of every person named in their paperwork, explaining exactly who they are. So I do appreciate that he is not just letting MSP kind of like get away with not turning stuff in. He's like, no, I'm going to need more information from you guys, which is, thanks, because that's true. So then on August 7th, he endorsed the motion to compel compliance with the deposition subpoena. The witness, Aidan Carney, shall appear on one of the 2 dates as selected by plaintiff's counsel for his deposition. Then Kieran Murphy joins the team for the McAlberts. I thought I had a picture of him. No, or was that just not the right one? There we go. He's also representing all of them here and in Ham v. Karen Reed. Then on August 14th, defendant Karen Reed's response to the August 6th court order regarding motion to compel MSP. So Karen is asking the court to force MSP to hand over specific communications they had been keeping private. The court, as we just said, asked Reed to explain why she has the substantial need for these records. The MSP has been hiding them by claiming they are confidential attorney work product or protected by attorney-client privilege. Reed's lawyers argue that the MSP hasn't proven these communications are actually confidential and that they cannot use general excuses to keep them secret. So and this is important because the O'Keefe family is suing Reed, claiming she caused them emotional distress by making up a false narrative and an intentional disinformation campaign regarding John O'Keefe's death, hence the need for Turtle Boy and MSP and all of that. So Reed's actual defense is that the state police conducted a corrupt bias investigation and framed her. Now, which many of us have come to that conclusion after watching the trials. You're like, oh, geez. Oh, wow. Okay. Well, this is not great. Now, because of this, communication between the state police and the prosecutors who handled her criminal case are highly relevant. If she can use those records to prove the investigation was indeed corrupt, she cannot be held liable for inventing a fake conspiracy. So this not only helps her in this case, but helps with the defamation lawsuit with him as well. Reed's lawyers point out these are two-way conversations between the state police and the Norfolk District's attorney's office. And since the DA's office already blocked her request to get them, the state police are the only remaining source for the critical evidence, because for neither one of those entities want these emails to come out. I wonder why. All right. And so then we go to August 20th. We have our last hearing. It's a whole 3 minutes. You don't even have time to go to the bathroom. Oops, whoops. That's not what I meant to do. And there's Jason Crotty here. Who is he an attorney for? MSP, I think. I don't remember. We haven't seen him before. All right. So let's give this last hearing a listen to.
Morning, Your Honor. May I proceed?
Yes, please.
Good morning, everyone. The matter before the court is civil action number 2483
That guy's hair and eyebrows?
CB00692.
Wow.
Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CNF McCarthy's et al. Your Honor, on behalf of the defendant Karen Reed, we have attorneys Arthur Maravellas and Aaron Rosenberg. And on behalf of Michael Proctor, the other interested party, we have attorney Jason Crotty.
Oh, so this is Proctor's attorney. Okay. All right. And then Arthur and Aaron are Karen Reed's. We don't see Arthur very much, but he's there now.
Present by Zoom.
Morning, counsel.
Morning.
Morning, Your Honor.
So we had a request to make 2 letters addressed to the court, emailed to the court, addressed to me on June 26th to be made part of the record. There's also been a request to impound such letters. Ms. Reed does not oppose the docketing of such letters under an order of impoundment. I can enter an order of impoundment for good cause shown and in accordance with applicable law only upon having a hearing. That's the purpose of today's hearing. I remind counsel that the rules require that those participating in the hearing preserve the confidentiality of the material that is at issue. Again, I noted that Ms. Reed did not oppose the docketing under an order of impoundment. I don't know who's going to speak for Ms. Reed, but counsel, do you wish to be heard further beyond what is included in your written submission on the issue of impoundment of such letters?
Morning, Your Honor. Aaron Rosenberg for Karen Reed. No, you're correct, and we're fine with what we submitted in writing.
Attorney Crotty, do you wish to be heard further beyond what is in your written submission on the order of impoundment?
No, Your Honor.
This could have been an email. Your Honor. We didn't
So
need a
after
hearing.
hearing and having balanced the rights of the parties and the non-party deponent based upon the particular facts of this case and taking into account all relevant factors, including but not limited to the nature of the parties and controversy, the type of information and privacy interest involved, the extent of community interest, I find good cause to impound and so order the impoundment of such letters for a period of up to 30 years.
30
I recognize
years.
that the fear of unjustified adverse publicity is not sufficient to constitute good cause. However, a legitimate expectation of privacy
We'll talk.
ordinarily is sufficient to constitute good cause. So I'm going to have clerk, here you go, Madam Clerk,
Thank you, Your Honor.
docket the letters under the order of impoundment. Anything else, counsel?
No, Your Honor.
No, Your Honor. Thank you.
Your Honor, thank you.
Okay. Thank you very much.
And
Thank you
that was
all.
it.
Thanks.
We don't even know when the next hearing is going to be. So just our last point here is, so the judge endorsed this, right? He said after the hearing and having balanced the rights of the parties and the non-party deponent based on the particular facts of the case and taking into account all relevant factors, including but not limited to the nature of the parties and the controversy, the type of information and the privacy interests involved, the extent of community interest, I find good cause to impound and so ordered the impoundment of for a period of 30 years. What in the fuck is in those letters that you're like, nobody can see this for 30 years? What? That's kind of wild to me. The letters that are to be docketed. I recognize the fear of unjustified adverse publicity. Unjustified is not sufficient to constitute good cause. However, a legitimate expectation of privacy ordinarily is sufficient to constitute good cause. So that's why I was ruling not because of the adverse publicity, but still 30 years. 30 years? That seems kind of wild to me. Well, you guys, we did it. Now you guys are officially caught up, myself as well, in the O'Keefe v. Reed, C.F. McCarthy's and Waterfall's wrongful death civil lawsuit. So anytime something new comes out, a new document, if it's, something good or a hearing, we're gonna watch it together. How fun is that in real time? So now what are we gonna do next? I'm glad you asked. I'm glad you asked. And so next Tuesday, or I'm sorry, next Monday, we are going to start going and covering the ham. That's Brian Higgins, Brian Albert, Colin Albert, Jen McCabe versus Karen Reed and Turtle Boy Aiden Carney for a defamation lawsuit. Now, oh boy, we've got a lot of work to do, I think, to really understand this case and the points of view. And it's going to be a journey. It's going to be a journey. It's going to take us several weeks just to go through this complaint because they add a lot of footnotes to things that were said on Aiden's lives or in his articles. And I think, you need context to a lot of these things. So, and I don't know most of it because, like I said, I haven't followed him, so I don't really know. So in order to make sure we understand everybody's accusations, we have a lot of stuff to read. We have a lot of stuff to watch. We have a whole ass trial that we pretty much have to watch because they're going to bring it up so much. And so many specific testimonies are going to be talked about a lot. So I was like, fuck it. Let's just rewatch the first trial. Since some of you have never seen it before, there's quite a few witnesses I didn't watch in the first trial. So we're going to go on a journey together and it's going to be intense, but it's going to be wild. Very, very wild because listen, Turtle Boy, not for everybody. All right. Is he crude? Yes. Is he crass? Yes. Does he say words that a lot of people aren't going to like? Yes. But this is a defamation case. It's about, is what he's saying not true? And are they lies? It doesn't really matter if you like, in this case in particular, it doesn't really matter if you like or dislike how he words things or says things. It's a matter of, is it lies? Is it made up? So that's one thing. It's going to be hard for, I think, some of you to keep that in mind. But that's what it's about. So it's I'm really, really excited to get into it again. It is one of those trials that I don't like to rewatch a lot of trials, but there is never a dull moment. And it's truly just I mean, in most trials, right? First responders, uninteresting to watch usually, right? Not that interesting. Turns out they're very interesting in this case. A lot of witnesses who shouldn't be problematic are, and it's wild to behold. So it is, in fact, one of the most fascinating trials I've ever seen as well. So we're going to start with the first one. We'll be doing that on weekends and covering the Ham v. Reed and Turtle Boy, going through those documents, making sure that, we understand what's being said or not said throughout the whole thing because it's fucking nuts, you guys. It's crazy. So I'm very excited to get into that. Where it's something else. So, and I mean, honestly, rewatching the trials again is relevant to the three other cases: the wrongful death, the federal civil lawsuit, and Reed versus MSP in Canton. So we might as well get caught up on and refresh ourselves because the earliest trial date would be next year. So, and we have not one but two trials to rewatch. So it's going to be a good time. We're going to have like rewatch parties. Hopefully, I'll have some other people on with Buff and I who are going to, watch and converse about all the bananery that happens. So Sam says it just keeps going. The drama is always top tier with the legal teams. Yeah, it is. Yeah, it is. So I'm very, very interested in it. 3 Clark Monty says some people don't like Turtle because he is dangerous and harms people behind their backs in awful, unethical ways, and because he has been undermining opposing Karen Reed since at least 625. Well, I could say this. Is that relative to the civil suits, or is that just like, behind the scenes drama? Because I don't particularly care about behind the scenes drama. I know that there's a lot, and I was like, oh, I can only handle the drama that it has to do with the case at hand, because otherwise we'll be in the weeds before we know it. So anyway, we're going to learn a lot of stuff together. I'm really excited about it. And I can't wait. So we'll be starting that whole journey next Monday at 10 a.m., starting with the complaint that Ham filed against them. So it's going to be a great time. Tell me Buffy is coming on live. Her knowledge of the case is amazing. Oh, yes, of course. She was like, yes, please. I would absolutely love to rewatch them again. And you should come on too, Sam. I'm going to peer pressure everybody to come on for our rewatch parties. But that is all I have for you guys today. So, Lady in Gray says, Aiden is an acquired taste for the most part. I like him, but I wouldn't say I'm a turtle writer. 3 says, I think he is innocent of criminal charges against him. Not sure about the defamation, but I can't ignore lived experience in other matters. Oh, I don't know what you're referring to, but I also do not know anything about his criminal charges. I just got done documenting all of the Karen Reed stuff. And then next is the many cases of Turtle Boy, which is a longer list than I knew of. My goodness. Yes. Yes. Oh, we should work something out, Mary. That would be great. So, it there's a lot. I can only do so much at one time because I also have other cases I have to cover. So, anyway, that's what we'll be doing together for the next while. And again, I'm really excited to go through it all again. So, you know, it is an extraordinary case. It really is. Who's right? Who's wrong? We'll have to see and explore more. So you can do evenings and weekends. Well, guess what? The watch parties are sometimes on the weekends. That's because I have some other people that would have come on who are only free on the weekends and not during the day. So I'll let you know because I'm going to finish sorting it all out today so I can let other people know so they can pick their dates if they want to come on. So Um, Lady Gray said, by the pure definition of defamation, he didn't harm anyone's rep. They did it to themselves, like Amber Heard. I mean, that's why I wanted to do the defamation case because next, because it is, that's the thing, right? Like we have to watch the trials in order to be like, okay, to really form our opinion. Because, like, I didn't know anything about Turtle Boy when I watched the second trial. He didn't influence me in any way. I didn't read his blogs. I didn't watch his videos. I was influenced by Buffy, who said, Llama, and my other friends, you need to watch this trial. You're going to lose your mind. And I did. And then I watched with my own eyes and ears and was like, why is everything so weird? So I'm really excited to see how it all ends up, now that there's all this other information that I wasn't privy to see how it goes. And defamation is a really interesting subject as well. So, all right, friends. Well, I'm going to go. I got work to do. If you haven't yet, please like this video, subscribe, hit the notification bell so you don't miss when we go live to talk about him. I will be back Thursday to cover more Laura Owens and the David Gingras blogs. Ooh, gosh, it's going to be a long day. Might have to do day drinking that day too. And leave a comment. Let me know what your thoughts are about everything. And I will see y'all later. Until next time, everybody, go forth and be amazing. All right. All right. Bye, friends.